Good evening. Thank you for joining the week 5 problem solving session for the NPTEL course on environmental impact assessment. And this course is being taught by Dr. Harshit Social Lakra, who's an assistant professor at the Department of Architecture and Planning, Indian Institute of Technology, Roorkee. For this course, we have two PMRF teaching assistants. I am taking the session 1 on Saturday. I'm Isha Rathod, PMRF and Research Scholar at the Department of Architecture and Planning, IIT Roorkee. Another session is being taken on Tuesday by Ms. Monica S., who's another PMRF and Research Scholar from the Department of Architecture and Regional Planning, IIT Kharagpur. So the session was supposed to be taken yesterday, but due to some issues on my end, I will be taking the session today. But the session is usually taken on Saturday. And so a few housekeeping rules. Please mute yourself for the session. And if you have any questions or answers, you can post them in the chat box. I will be moderating the chat box as well. And if you have any questions, you can raise your hand and mute yourself for asking questions when instructed. And so the outline of the session is that we're going to discuss the highlights from each week, that is each of the lecture units and their key takeaway and main points. And then we're going to practice few assignment questions based on the previous run of the NPTEL course and look at the solutions for the assignment questions. And then we're also going to look up at this week 5 assignment because the deadline for the same has passed. And we're also going to look up at queries if we have received any for this week's content in the discussion forum. So week 5 was about connectedness, connected spaces and subspaces connected on the real line or the intermediate value theorem. This was also an extension of week 4 where we talked about laws, policies around the other the main environmental parameters. So now we're going to talk about the highlights from week 5. So we had lecture 21, which was on EIA law, policy and institutional arrangements for EIA systems. This is part 9, which talks about cultural heritage and health. We have talked about 8 parts before this in week 4 as well for air, water, soil, land, and etc. And so this week we are going to look up at the other EIA systems, that is the cultural heritage and health in this module. So in this lecture, we basically talked about cultural heritage and the relating international heritage conventions, treaties, and charters, and their purpose and implication on the EIA process. So, cultural heritage and environmental assessment, as defined by the World Bank in 1994, relates to any legislation that protects a particular type of places or different types of places and sets out procedures for their protection. And these spaces can be culturally rich, or they can be sensitive areas which require protection. They can be religious places or biological places. And then it also deals with formulating and planning the land management, zoning, and other acts which provide general protection to these spaces and building and the development around these spaces. And it also looks up at the acts which require the recording of data on cultural sites, that is bookings, listings, visiting tourists, and all of those things, and regulates the numbers which are efficient for protecting as well as. And then it also looks up at the acts which protect natural areas which are biologically rich or sensitive and house certain species which are useful. And then moving on, we look up at the International Heritage Convention, treaties, and charters. So in the year 1954, we had the Convention for the Protection of Cultural Property in the event of armed conflict. This is also known as the Hague Convention. And it provides a system of protection of cultural property in situations where there are disputes and armed conflicts between international or domestic parties. And this has been signed by 128 state parties or countries. And you can read more about them in the links provided, but this is just the general outline of the convention. And in 1964, we had the Venice Charter, which is also the International Charter for the Conservation and Restoration of Monuments and Sites. And it looks up at the principles of conservation and the restoration of monuments and sites, specifically in a monument setting. And this is one of the important charters for conservation studies as well. And in 1970, we had the Convention on the Means of Prohibiting Illicit Import, Export, and Transfer of Ownership of Cultural Property, also known as the Paris Convention. This is also one of the important conventions, and it prevents the trade in illegally obtained cultural objects or artifacts. And this has been signed by 132 state parties or countries. And then in 1972, we had the convention which concerning the protection of the world cultural and natural heritage, also known as the World Heritage Convention. And it established a system of collective protection of natural and cultural heritage, which is of outstanding universal value. And this has been signed by 193 state parties. And you can read more about them in the links given. And then in 1992, we had the Convention on Biological Diversity, which we looked up in the module on biodiversity as well. So it recognizes the cultural value of biodiversity and looks up at its components and their protection in indigenous and local communities. And it also looks up at the sustainable use of biological diversity. And moving on, we had the 1994 ICOMOS NARA document on authenticity, and this builds on the principle of the Venice Charter, which we talked in the previous slide. And in 1999, we had the ICOMOS International Cultural Tourism Charter, which aimed to make cultural tourism sustainable. That is, because tourism happens. The practices of tourism are unsustainable mostly. This was aimed towards making the cultural tourism at cultural sites sustainable, and it provides key definition of culture, cultural heritage, and acknowledges the adverse effect tourism has on heritage assets and communities. And then in 2001, we had the Convention on the Protection of the Underwater Cultural Heritage. It set out the basic principles for the protection of underwater cultural heritage and detailed state cooperation systems and looked up at widely recognized practical rules for treatment and research of underwater cultural heritage. And this was signed by 56 state parties. And moving on to the year 2003, we had the Convention for the Safeguarding of Intangible Cultural Heritage. So it aimed at safeguarding the use, representation, expressions, knowledge, techniques that communities and groups and individuals should recognize as an integral part of cultural heritage. And this intangible heritage, so intangible is anything which you cannot see or which you cannot directly see or perceive, but it is like the hidden or the unfeltable type of aspect of heritage. So, in terms of oral traditions or tradition practices being passed on to next generations, knowledge systems, rituals, festive events, practices concerning nature, universe, traditional craftsmanship knowledge, which is passed from within the same families and techniques, and this aimed at protecting all of these intangible forms of cultural heritage. This convention was aimed towards that, and this was signed by 174 state parties. And then in 2008, we had the Quebec Declaration on the Preservation of the Spirit of Place, and this aims to preserve the spirit of place, which is through safeguarding the tangible and intangible heritage associated with that space. And the spirit of space is defined as either living, social, and spiritual nature. And it declares that the intangible cultural heritage gives a richer and more complete meaning to heritage as a whole, and that it must be taken into account in legislation, conservation, and restoration. So it identifies the aspect of intangible cultural heritage and states its importance in preserving the spirit of a place. Again, in continuation, yeah, okay. So this is just the same. And then we had the ICACON guidelines, which looked up at which are voluntary guidelines, which look up at the conduct of cultural, environmental, and social impact assessments relating to developments proposed on a place, and which will have likely impact on sacred or conserved sites, which are associated to lands and water, which are traditionally occupied by indigenous and local communities. Then we also had the UNESCO CBD 2014 Joint Program on Biological and Cultural Diversity, and it identified the concept of biocultural diversity, which is the link between cultural and biological diversity of a place, specifically with reference to the cultural services which the ecosystem provides in a particular space, and looks up at how to preserve and conserve them and to build sustainably around them. And then moving on, we also had the cultural keystone species, which was defined by Garibaldi and Turner in 2004, which defines cultural keystone species as culturally salient species that shape in a major way the cultural identity of people. And their importance is reflected in the fundamental role these species play in diet, materials, medicine, and our spiritual practices. So we have basically four type of species which Garibaldi and Turner identified in 2004, and they are the keystone species, the dominant species, the rare species, and the common species. So keystone species are species which, in a major way, define the identity of a space or an ecosystem, and they are in terms of their diet, that is the amount of diet that they consume, in terms of the materials or medicinal values that their products have, that they're like yeah, and then again, if they are related to any of the spiritual practices being performed by the people around them. So those are keystone species. Then again, dominant species are species which are largely present in the area and are much larger in number, and basically dominate the ecosystem of the space. And they are again controlled by the keystone species in terms of regulating their numbers, because the keystone species shape the ecosystem, helps in regulating the dominant species as well. And then rare species are species which are limited or are occasionally present in the ecosystem because of either the requirement of season or favorable conditions. So things like fungi or spring flowers, which only bloom in, so fungi only comes up in moist marsh conditions, whereas spring flowers come only in the season of spring because the conditions are favorable at that point of time. And then common species are things like weeds, grass, forest ferns, and flies, which are present in the biological environment in naturally in a large number. So they are just common species. And then then in lecture 21, we also looked up at the aspect of health and key legislation, guidance, and standards relating to health and their implication on the EIA process. So we had the Human Health Risk Assessment, which is the HHRA, and this basically looked up at the chemical hazards. This looks up at the chemical hazards, and this was presented by the WHO. And then again, we have the International Finance Corporation Performance Standard 4, which looks up at the community health, safety, and security, and infrastructures and their risk associated to these, and their risk associated to the environment. And then we also had the 2022 Corporate Sustainability Report, and this has a lot of chapters, but chapters 11 to 36 are on are on protecting the environment and empowering people. So it talks about climate change, environmental risk management, water, biodiversity. And in empowering people, we have diversity and inclusion, human rights, creating prosperity, sustainable development goals. And these are basically multinational industry. So multinational industry corporations basically have to undergo a health impact assessment. And so these are the internal requirements for conducting a health impact assessment within the uh, industry corporation uh, within multinational companies, basically. And these are some of the aspects in terms of social and environmental parameters which they should meet. And this provides guidelines on those areas for them to meet. And then in health, we also had the International Council on Mining and Metals, ICMM, which provided this good practice guidance on health impact assessment. And then we have several guidebooks and toolkits for again health impact assessments, guidebooks, toolkits, textbooks, and practice standards, which you can refer to if you want to later. And then moving on to lecture 22, we had the EIA law policy and institutional arrangement for EIA system. This is part 10, which looks up at land acquisition, resettlement, and livelihoods. So this defined the key concepts and definitions relating to land acquisition, resettlement, and livelihood. So on the left-hand side, we have the negative impacts of these settlements, which are landlessness. So when resettlement happens, the community living in a particular area have to be displaced from that area because of a major project coming up. So their land is being taken, and then because their livelihoods are dependent on the land on which usually the livelihoods of these communities are dependent on the land on which they occupy and its neighboring surroundings. They become jobless as well because their livelihoods are threatened. They become homeless because their land is taken, their houses are taken, are being replaced because of this major project coming up. Then there's this marginalization of this community. There's increased morbidity because of the surrounding all of these stress and concerns relating to their land being taken. There's food insecurity, there's loss of access and social disarticulation. And on the right, we have transition and projects outcomes. So when a major project aims at doing land acquisition and resettling the people of the land which they are occupying, they have to transition all of these negative impacts of that their resettlement will happen will cause to the people to the current occupant of the land. So they have to transition them into project outcomes. So they have to do like land-based resettlement. They have to give new land to these for in equivalent amount to the people whose land they are taking. Then they have to provide re-employment opportunities. They have to fund the reconstruction for these people. They have to look up at social inclusion of these communities and the new surrounding they are being uh, in the new surrounding they are being given. They have to look up at their improved health care, to look up at adequate nutrition being given to these communities, and the restoration of community assets and services, and the networks and community rebuilding. So all of these negative impacts need to be translated into project outcomes for the successful resettlement process to happen. And they have to reflect this in their EIA process for them to get approval. And so then we had like the certain key concepts and definitions. So for resettlement is this planned process of relocating people in communities from one place to another. Then there are two types of resettlement. There's voluntary resettlement and involuntary resettlement. So involuntary resettlement occurs in situations where project proponents have no alternative to government expropriation or other enforcement mechanisms, and people cannot be compelled to surrender their land. So voluntary resettlement is when in situations where the government has the right to take up their land, but they also have to do all of the resettlement transition outcomes, which we talked about in the last slide. So in these situations, they have no alternative because the government is asking them for the land, so they have to surrender their land. Whereas involuntary resettlement is when the without the informed consent of displaced persons, or if they give their consent without having the power to refuse resettlement. So involuntary settlement is based on like when the so in the EIA process, it's like a dual process where you discuss it with the project developers as well. There's like a community meeting, and you have to agree to the resettlement process and put forward your demands. And both parties have to agree for the resettlement process to happen. Whereas an involuntary resettlement, this consent is not being taken, and the power to refuse by the community is not put into force. So that is the involuntary resettlement. And then we have a few more concepts, which is the eminent domain, which is the right of the government or its agent to expropriate private property for public use with payment of compensation, of course. So, like I said, the government has the power to take the land from people, but they also have to pay the compensation. So they can take up private land for public use. So an example of this is when roads are widened, so the government can take up that land, and in terms of the extra width for making the roads wider. So this is the expropriation of private property for public use by the government. Of course, they have to pay some compensation around it, but the government has the power to take up private property for public land for public use with compensation. And then we have land expropriation or negotiated agreement. This is the process where a public authority, usually in return for compensation, requires a person, household, or community to relinquish rights to land that it occupies or otherwise uses. So this is the process where the negotiation over the agreement happens. So if the project requires a large area of people to give up their land, each person from a household or a community representative is going to have to sign the agreement, which states that they are okay with whatever the compensation is given to them in terms of land or monetary value, and they have to sign it for the land to change ownership. And then compensation is payment in cash or in kind for an asset or a resource that is acquired or affected by a project at the time the asset needs to be replaced. So compensation can be either in terms of cash or any other monetary value for the community assets or resources or land which is acquired or affected by the project and needs to be replaced. So they have to give compensation in terms of the damage they are doing to the community, basically. And then host population is people living in or around areas to which people physically displaced by a project will be resettled, who in turn may be affected by the resettlement. So host population is the population at the new area where the resettlement people are going to be sent to, like where they are going to be given the new land. So that is the host population because they are already living there. So they are also going to be affected by this large displacement of people around them. So they are the host population. And then we have vulnerable groups, which are people who, by virtue of gender, ethnicity, age, physical or mental disability, economic disadvantage, or social status, may be more adversely affected by resettlement than others, and who may be limited in their ability to claim or take advantage of resettlement assistance and related development benefits. So, vulnerable groups are groups of people who are, because of all of these factors around gender, ethnicity, age, disability, economic disadvantage. These are people who will be, so vulnerable groups are more affected because of any of the changes, especially resettlement, because they have limited ability first because of all of these limiting parameters, and they cannot take full advantage of resettlement and this assisted development benefits. So vulnerable groups have to be given like a special provision or they have to be taken into consideration when they are negotiating the agreement for resettlement. And then project affected households is all members of a household, whether related or not, operating as a single economic unit who are affected by a project. So like I said, one person from a household is going to sign the agreement, but then that one person from the household represents all of these members of the household, whether they are related or not related by blood, and but they act as a single economic unit for the agreement purposes. So they are one single economic unit who are affected by a project, by the development project. And then livelihood is the full range of means that individuals, families, and communities utilize to make a living, such as wage-based income, agriculture, fishing, foraging, and other natural resource-based livelihoods, petty trade, and bartering. So livelihood is like basically the jobs of the people being dependent on the surrounding areas uh, of the so all of these terms are relating to the land acquisition, resettlement, and livelihood aspect. So we're going to just talk about that aspect. So livelihood of the people who are being displaced. And then we have physical displacement, which is the loss of shelter and assets resulting from the acquisition of land associated with the project that requires the affected person to move to another location. So physical displacement is when you are physically displaced from your land because the land is being taken for development. And economic displacement is when people lose their source of income because of a developing projects. For example, if the forest is being taken as a is taken for the development project, then the people living in the surroundings of the forest are affected by the project because they were using the forest for gathering firewood and other ecosystem services. So their loss of income is associated with the forest development project. So that is economic displacement. So it is the loss of income streams or means of livelihood resulting from land acquisition or obstructed access to resources, land, water, or forests, which are resulting from construction or operation of a project or its associated facilities. So physical displacement is when you do not have a physical home and you are physically being displaced from your land. Whereas economic displacement is when you are affected because of land being taken, land from where you get your livelihood being taken for the development project. And then we have the cutoff date, which is the date of completion of the census and asset inventory of persons affected by the project. It also is the persons occupying the project area after the cutoff date are not eligible for compensation and or the settlement assistance. And it's also fixed assets such as built structure, crops, fruit trees, and woodlots established after the date of completion of the assets inventory, or an alternative mutually agreed on date will not be compensated. So, in order for the project to move forward, we the both the parties agreed to set off a cutoff date, and by that date they need to do a completion of. They need to have a accurate number of people living in that area and their assets, and like people affected by the project, and they do it. So people occupying the project area after the cutoff date will not be counted in the compensation or the settlement assistance part of the project. And fixed assets, even after the date of completion of assets inventory, and another mutually agreed on date will not be compensated. So by the cutoff date, whatever number of people were living in that area and their assets is counted and move forward for the resettlement process and for calculating the compensation. But anything after that cutoff date is not being counted in the compensation stage and will not be compensated. So, and then we have the international financial institutions and Equator principles. So in the financial institutions, we have the World Bank's environmental and social framework, and it provides like if you look up at the list of contents, so it's about Standard 5, which looks at land acquisition restrictions on land use and involuntary resettlement. And it talks about the requirements for displacement, collaboration with responsible agencies and some national jurisdictions, technical and financial assistance. And then it also talks about resettlement plans, frameworks, and process framework. And then we also have the international finance corporations performance standards on environment and social sustainability. And again, performance standard 5 talks about land acquisition and involuntary resettlement. And then we have the Equator principles, or also known as EP. And they serve as a common baseline and risk management framework for financial institutions to identify, assess, and manage environmental and social risks when they are financing projects. So, Equator principles apply globally to all industry sectors and to basically five financial products. So, these five financial products are project finance advisory services, project finance, project related corporate loans, bridge loans, project related refinance, and project related acquisition finance. So these are basically for the financing institutions to identify their risk and assess and manage the environmental and social risks which the projects which they are financing or giving money to have on the environment and the social communities. And these are the five products in which uh, these Equator principles apply globally. And so they are basically a sustainable framework for global finance industry. They have 127 financial institutions in 38 countries who have adopted these Equator principles. You can read more about them in the link given. And these standards are applied in EIA and development projects. So if you look up at the this is the principles book, and then you have the principles which talk about categories of projects, financing projects, their environmental and social assessment, the standards which are applicable to them, and all of those things, stakeholders being involved, grievance mechanism, that is these community meetings for mutual agreements, uh, reviewing process, monitoring after the project is completed, reporting and transparency. And then we also have the so financial institutions who adopt Equator principles need to ensure that that the projects which they finance, they are developed in a socially responsible manner, and they do not affect the environment and the social communities where these projects are being developed. And then moving on, we also look up at the resettlement framework and resettlement action plan in the lecture. So this is uh, to avoid and minimize the displacement by exploring alternative project design. So the first step to the project which requires the settlement is to provide the need for the project and why this particular site has to be why so the first step is to minimize damage, that is to minimize the first eviction and to minimize displacement of people and the damage that the project will cause to the environmental assets. The first step is to avoid all of these things and then to establish why this route is the only possible way. So the first step is to avoid all of this thing, and then it is also to yeah, so it is to minimize adverse social economic impacts for land acquisition or restrictions on people. Restriction on land use, provide compensation for loss of assets at replacement costs, ensuring that resettlement activities are implemented with appropriate disclosure of information, consultation, and the informed participation of those affected to improve or restore the livelihoods and standards of living of displaced persons, and to improve living conditions among physically displaced persons through the provision of adequate housing with security of tenure at resettlement sites. So it basically talks about that the first thing is to avoid all of this damage, and if it is not avoidable, then to um, develop in such a way that social and economic impacts on these communities are limited, and that they're given compensation at the correct replacement rate, and that resettlement activities are done by considering both the parties involved, that is the developer side as well as the community which is being displaced. And then we also look up at the vulnerable groups, which is the last point, to consider these vulnerable groups and to ensure that they are adequately compensated. And so another term is local procurement, and this refers to the purchase of goods and services from local businesses. And this occurs in emerging markets and in developed markets where local communities have expectations about participating in new opportunity. And this is favored as a strategic business tool by international companies in the extractive industries. And this was presented in the Strategic Community Investment, which is the International Finance Corporation uh, corporation's book, which we looked in the last slide. And then, as per this framework, we have the you need to prepare a resettlement framework. Uh, so this is from the International Finance Corporation's Performance Standard 5, which talks about resettlement. And as per this document, you need to prepare a resettlement framework. And this resettlement framework includes these three documents, which is the Resettlement Action Plan, or the RAP, the Livelihood Restoration Framework, and the Livelihood Restoration Plan. So it basically looks up at the entire plan for the settlement, from including the site to the number of housing units that are required, all of this, the area equivalent, and both the parties have to agree to this. To these three documents. Then again, you look up at the livelihood restoration plan, which looks up at the restoration plan and framework, which is first they define the framework that these are the job opportunities that they're going to create. Uh, and then both the parties again have to agree to both of these documents as well, which talk about the livelihoods of the community being displaced. And then in terms of the social impact of the project, you need to look up at all of these components, that is the land, people, community, culture, livelihoods, infrastructure, housing, and environment. So all of these aspects need to be considered in the resettlement project as well. And moving on to lecture 23, which talked about the EIA law, policy, and institutional arrangements for EIA systems, part 11, which talks about land acquisition in the Indian context. So we had the right of property. So according in the Indian constitution, the right of property is not a fundamental right, but it is a constitutional right, which means that so we have two types of right, which is the fundamental rights and the constitutional rights. The fundamental rights are like right to live, right to speak, and all of those things, whereas constitutional right, so these are fundamental rights are rights which all the individuals have, whereas constitutional rights are written in the constitution and are applicable at particular instances only. So right to property is not a fundamental right. That is, not all the people in the country will have property, basically. So each person does not have a property is the translation of this statement. You need to buy property and to maintain property, but the government has the right to take the property, to take private property for public use again. And so then we also look up at the right to fair compensation and transparency in land acquisition. So this is basically where we talk about the compensation and transparency in land acquisition process. So we are going to look up at how compensation is determined and how the communities participate in the compensation process in a land acquisition scenario. So the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act of 2013 is a humane, participative, informed, and transparent process. It causes least disturbance to the owners of the land and other affected families, provides just and fair compensation, provisions for affected people for their rehabilitation and resettlement, and persons become partners in development. So it brings people together in a transparent way for them to agree to the land acquisition and resettlement process, and it provides a fair and just compensation, which is again agreed by both the parties. So the application of the act is in basically four stages, which is land acquisition, compensation, rehabilitation, and resettlement. And they are applied. So land acquisition can happen in a number of scenarios. So the first scenario is when the government requires land for building naval, military, air force, and armed forces of the Union, parliamentary forces, and other work related to national security or defense of India or state police and the safety of people. So the first step is so the first purpose or application of the act is when the government requires the land for defense purposes or for national security purposes, for example, building training camps or building military facilities. So they're going to take up the land because they have done their due diligence on why this particular site is important, and they will not and they will take up the land in this scenario. The second case is for infrastructure projects, which are all activities or items listed in the notification of the Government of India and the Department of Economic Affairs, excluding private hospitals, private educational institutions, and private hotels. And this also involves agro processing, projects relating to industrial corridors or mining activities, national investment manufacturing zones, and as designated in the National Manufacturing Policy. Then it's also applicable in projects for government administered, government aided educational and research schemes or institutions. Also, for projects for sports, healthcare, tourism, transportation, or space programs, and any infrastructure facility, or as may be notified in this regard by the central government and other tabling of such notification in the parliament. So, in all of these cases, the government acquires land. uh, in A, it's for national security. In B, it's for infrastructure development and the development of the country, especially in the infrastructure sector. For example, in building specific public use buildings for increasing the agricultural processing facilities, for industrial corridors, for facilitating the mining activities because the mining resources are present in particular locations. So those for those activities as well, you require land acquisition and resettlement. Then for building up like education and research facilities for tourism, transportation, space programs, healthcare, sports, all of these facilities which the government thinks is essential for the development of the country can require and can lead to land acquisition and resettlement processes. Then again, this can be applied to projects for project affected families. Again, families which are affected by uh, the land acquisition or by natural calamities, and all of those things are again included in this act. Project for housing for specific income groups, low income groups, or vulnerable groups. Project for planned development or improvement of village sites or any site in the urban area, provision of land for residential purposes for weaker sections in rural and urban areas. So again, because villages develop in a very irregular fashion, the government can take up that land and provide a scheme which sort of gives a regular pattern to the village. And because all of these villages agree in a very organic or natural way and have roots and have roads and other things which lead to a um, larger time for moving around in the village and all of those things. So they can uh, the they can develop these villages again. So that's like the improvement of village sites and planning of village sites. And then again, for projects for residential purposes to the poor or landless, or the persons residing in areas affected by natural calamities, or to persons displaced or affected by reason of the implementation of any scheme undertaken by the government, any local authority, or a corporation owned or controlled by the state. So these are the cases in which this act is applicable. And this is applied for two types of project, that is for the public-private partnership project or for private companies for public use. And in both of these cases, consent shall be carried out along with social impact assessment study. And this applies to cases where a private company purchases land equal to or more than such limits in rural areas or urban areas, or also in the case in which a private company requests the appropriate government, that is the state government, for acquisition of a part of an area so prescribed for the public purpose. So again, the this can happen in two cases, so which is basically in a public-private partnership, which is again towards the development of the country, infrastructure projects like that, and again for private companies which are developing the projects for public use. And in terms of social impact assessment study, these are the following steps which needs to be done. So it includes a review of the public purpose, the estimation of the affected families and the number of families among them which are likely to be displaced because of the development of this project, the extent of lands, public and private houses, settlements, and other common properties likely to be affected, ensuring bare minimum extent of land for acquisition, ensuring all alternatives are reviewed, study of social impacts of the project and the nature and cost of addressing them, and cost benefit analysis. So, all of these things need to be included in the social impact assessment study for the project. And again, there need to be like a public hearing of the social impact assessment at the affected area to ascertain the views of the affected families to be recorded and included in the social impact assessment report. So this is the transparency where all of these things which we talked about in the previous slides are being communicated to the people who are affected by the project. And then also the publication of social impact assessment study report and the social impact management plan in the local language to the panchayat, municipality, or the municipal corporation. So again, the results from this social impact study, including the public hearing and the concerns of the affected family, is being published in a report, which is again published in the local language to be sent to the panchayat, municipality, and municipal corporation of the affected area, so that they can see all of their concerns and uh, views are being reflected in the social impact assessment report. Uh, they also need to safeguard for food security if it's related to a agricultural area or the um things like that. The only exception for this is for like linear projects, which are like railways, highways, major district roads, irrigation canals, power lines, because they cut right through the agricultural field. So their impact cannot be assessed just by because they happen on a very linear line. And then again, so in the rehabilitation and resettlement scheme, these are the steps which need to be done. So the collector, administrator, and the administrator is required to conduct a survey and undertake a census of the affected families. And in that survey, it needs to record the particulars of lands and immovable properties being acquired of each affected family for the purpose of rehabilitation and resettlement. The administrator also needs to record the livelihoods lost in respect of land losers and landless whose livelihoods are primarily dependent on the land being acquired. So both the physical displacement as well as the economic displacement needs to be recorded here. And a list of public utilities and government buildings which are affected or likely to be affected, where the settlement of affected families is involved. Details of amenities and infrastructure facilities which are affected or likely to be affected. Details of any common property resources being acquired. Then it needs to draft, they need to draft the rehabilitation and resettlement scheme, ensuring the time limit, which is the cutoff date for implementing rehabilitation and resettlement scheme, needs to widely publicize this in the affected area, discuss the concerns of the Gram Sabhas or municipalities, that is, discuss the concerns of the people who are affected by this development project being reflected and being taken into consideration at this stage, and then holding a public hearing in a prescribed manner so that all the views of the people affected are being conducted and recorded in the social impact assessment report. And then claims and objections raised in the public hearings are to be recorded. And then it needs to review the rehabilitation and resettlement scheme, publication of the approved rehabilitation and resettlement scheme, publication of declaration summary of rehabilitation and resettlement, and then the award should be made within a period of 12 years from the date of publication of the declaration under section 19. And if no award is made within this period, the entire proceedings for the acquisition of the land shall relapse. And then determining the market value of the land by the collector and determining the amount of compensation being payable to the affected community. So, so this is the basic overview of the rehabilitation and resettlement scheme in terms of the steps which are undertaken. And then to calculate the compensation, you need to look up at the market value, the current rate for land in that particular area. Then you need to look up at the damage sustained by the person interested by reason of taking of any standing crops and trees which may be on the land at the time of the collector's taking possession. They also need to look up at the damage sustained by person by reason of severing such land from his other land. So if you have a larger property and a part of the property is being taken by the taken for the project, they also need to assess the impact of taking the part of the property instead of taking the full part, because it will have implications. And then you also need to look up at the damage sustained by the person interested by reason of acquisition, injuriously affecting his other property, movable or immovable in any other manner, or his earnings. Then compelled to change his residence or place of business, if such a case occurs. And they also need to look up at decrease of the property profits of the land and any other ground which may be in the interest of equity, justice, and beneficial to the affected families. So these are all the parameters which they need to consider. Then again, they need to make special provisions for scheduled castes and scheduled tribes, which are vulnerable groups in India. And so they need to first ascertain that as much as possible, no acquisition of their land is being made. And if it is made, then they need to show that this was the last possible option available to them, and that this was basically unavoidable for the development of the project. They need to take prior consent of the gram sabha of that area or the panchayat of that area. And then, in case it was like an involuntary displacement, a development plan should be prepared, laying down the details of the procedure and any other special drive together with the land acquisition. And then they need to show the development plan, which contains a program for the development of alternate fuel, fodder, and non-timber forest produce resources on non-forest lands within a period of 5 years, sufficient to meet the requirements of tribal communities as well as the scheduled castes. So they need to ensure that their livelihoods are as well not being disrupted. And they need to at least show that 1/3 of the compensation amount shall be paid to the affected families initially as the first installment, because these, like I said, they are vulnerable groups in India. And then these families should be resettled preferably in the same scheduled area or in a compact block, so that they are not uh, socially disintegrated, and they feel more at home. Then all of these resettlement areas need to be uh, provided to them free of cost for community and social gatherings. And any alienation of tribal lands or land belonging to these members and disregard of the laws and regulation of the time in force shall be treated as null and void. And in case of acquisition of such lands, rehabilitation and resettlement benefits shall be made available to the original tribal landowners belonging to the scheduled castes. And they need to also be given fishing rights in a river or pond if they were affected by because of an irrigation or hydropower project. And again, if they are relocated outside the district, they shall be paid an additional amount for the rehabilitation and resettlement benefits, which is usually 25% at the moment. Uh, okay. And then there are again some other benefits to them. So in a summary, there are various type of public purpose projects. You can have a public-private partnership project, or you could have a private company building project for public use. And then the public use projects can again be for national security, for the development, infrastructure projects for the development of the country, for people affected by displacement projects or by affected by natural calamities, and and projects which are built for facilitating the health, sports, space programs, and all of those things. And then prior consent is required in case of public-private partnership. This includes the amount of compensation being determined at the initial stage payable to these people, then the payment of compensation and the calculation of the compensation, then the links of the Land Acquisition Act and the accompanying obligation for resettlement and rehabilitation. That is the steps which need to be taken. Addressing the historical injustice where no land acquisition award has been made, return of unutilized land, increased share in the sale of acquired land, income tax exemption, strict restrictions on the on multi-crop acquisition only if necessary, share and develop land, fishing rights, in case it's affected by uh, a dam project or a hydropower project, time-bound social impact assessment, that is determining the compensation by the cutoff date, and the appraisal of social impact assessment report by an expert group and by the local group communities. So these are the key features of the Rehabilitation and the Resettlement Act 2013 in the Indian context. Moving on to lecture 24, we talked about EIA law, policy, and institutional arrangements for EIA system. This is part 12, and they talked about the socio-economic impacts assessment and resource efficiency. So we look up at social impact and the international guidance and standards around it. So social impacts are changes to one or more of the following, which is people's way of living, people's culture, people's community, their political systems and their political beliefs, their social environment, that is the hierarchy and their social standing in their community, the health and well-being of the people, and the personal and property rights of people. So any effect to any of these in any of these parameters is considered as a social impact, and this also needs to be documented in a social impact assessment report. And a few of the key agencies or corporations which look up at social impact are the UN Human Rights Council or the UNHRC of 1948. Then you also have the FIDH, or the International Federation for Human Rights, which presented this Human Rights Impact Assessment (HRIA). Then we also have the UN Environment through the United Nations Environment Program. We have the World Bank. We have the International Finance Corporation, which is again a World Bank Group, IFC. So in terms of the social impact assessment, so the International Finance Corporation has performance standards. So a few of these performance standards look at the social impacts of projects on people. So performance standard one of the IFC talks about risk management, and it looks at the integrated assessment to identify the environmental and social impacts, risks, and opportunities of projects. It also looks at the effective community engagement through disclosure of project-related information and consultation with local communities on matters that which directly affect them. And then it also looks up at client management of environmental and social performance throughout the life of the project. So it looks up at the risk management of people and their community engagements. And then objective standard, performance standard two talks about labor, and it looks up at provides guidelines and standards on fair treatment and non-discrimination towards labor forces. Uh, Provides states to maintain a good worker management relationship, talks about compliance by the development projects with relevant employment and labor laws. And it also talks about worker protection, especially for vulnerable groups such as children, and safe and healthy working conditions for the labor forces, and no use of forced labor. And in another international guidance, we have the International Association for Impact Assessments, Social Impact Assessment, which is the guidance on assessing and managing social impacts of projects. And this was published in 2015 by the principal author was Frank Van Cleef from the University of Groningen. And they talk about few key concepts, which is the social license. One of the few key concepts is the social license to operate, which talks about the level of acceptance or approval of the activities of an organization by its stakeholders, especially local impacted communities. And another concept it talks about is the free, prior, and informed consent, or the FPIC, which is a procedural mechanism developed to assist in ensuring the rights of indigenous people to self-determination. And also talks about the human rights due diligence, which refers to the exceptions in the United Nations Guiding Principles on Business. and requires and human rights that companies must carry out a due diligence process in order to ensure that the proposed business action, transaction, or acquisition has no hidden human rights risk. In other words, risks to people and communities, not only risks to the company. And it defines non-technical risks as the managerial, legal, social, and political issues faced by a project, in contrast to the technical risks in terms of the technical content. And it also talks about impacts and benefits agreement, which is community development agreements uh, being as negotiated agreements between project developers and the affected people. And it also talks about sustainable livelihoods, which is a way of thinking about communities and people in terms of their capabilities, their livelihood resources, and livelihood strategies they undertake to make their living and conduct their way of life. And they define livelihood as the way of life of a person or household and how they make a living in particular and how they secure the necessities of life. It also talks about shared value, which is in creating shared value. Uh, that is, rather than just considering the profit for shareholders, you also need to consider about social benefits to the shareholders as well as social benefits to the company. So, in a sense, creating a shared value system between the shareholders and the community and the company. So again, yeah, the social license to operate is again uh, so these are just what I talked about in the previous slides as well. And then in terms of social impacts, we have a few national guidance and standards. So we have the Green Book, which is the central government's guidance on appraisal and evaluation. And it talks about provides guidance on design and use of monitoring and evaluation before, during, and after implementation of a project, and the appraisal of alternative policy options in an inseparable part of detailed policy development and design. And then another topic which was covered in lecture 24 was resource efficiency and the international guidance and standards around resource efficiency. So we have the International Finance Corporation's Performance Standard 3, which talks about resource efficiency and pollution prevention. And then further resource efficiency guidance and standards are the United Nations Environment Program Annual Report, which is published in 2015. Then we also had the NEPA USA, which talked about the EIA process. We looked at this in the previous lectures as well. And we also had the European EIA Directive of 2014. So moving on to lecture 25, which talked about EIA law, policy, and institutional arrangements for EIA system. And this is part 13. And it talks about transport, landscape, and visual environment. So we, in the first part, we look up at transport policy and guidance on EIA for transport projects. So we had the World Bank Guide, which was published in 1997, and it looks at the integrating environmental thinking into road planning and management, and improving the communication among different disciplines and interest groups, where often use different concepts and terminologies. So, and then we have 5 types of environmental impact assessment which are applied to road projects. So these are project specific EIA, which says individual new roads which are built or the public transport system, but it looks at a specific project only. And then we have the programmatic EIA, which examines the number of individual projects which may be delivered together as a package or program. So it looks up at the number of projects ongoing or delivered together as a package or the program. Then we have the summary environmental evaluation, which focuses on specific categories of impact and their mitigation. Then we have the regional EIA, which examines all planned projects within a specified geographical area at the subnational level. So regional EIAs are specific to a particular region and projects relating to that particular region, especially road projects. And then we have the sectoral EIA, which strategically assesses all projects of a certain type, such as transport infrastructure, in a relatively larger geographical area. So, yeah. And then further documents to guidance on for transport projects are the European Investment Bank's EIB's Economic Appraisal of Investment Projects. And this was published in 2013. And this calculates economic returns of the projects using internationally accepted methods. And it looks up at beyond the financial consideration, it also looks up at the social economic costs and benefits to ensure that these projects are make a larger contribution to the society at large. Then, in terms of Indian guidance, we have the guidance for the environmental impact assessment of highway projects, which was published by the Indian Roads Congress, 1989. And then the environmental impact assessment guidance manual for highways, which was published in 2010. And both of these documents are towards highway projects. And then we also have the Indian Road Congress Code of Practice for Highway Projects, and they look up at certain things like these are again codes of practices which are relating to highways and highway construction and things. So you have highway road manual, you have things like use of fly ash in road embankments. All of these are Indian Road Congress further codes which help in defining the practices for highway projects and looking about certain parameters and things, issues relating to the projects. And again, in international practices, we have the International Goods Practices document, uh, which is again it provides the collection of good practices, guidance, and technical circulars and policies, which address the environmental issues, and they are grouped into three categories, which is planning and design, the construction management aspects, and management of sensitive receptors. And you can read more about this in the IA guidance manual on highways. And then again, we have the India's guidance document on Green National Highways Corridor Project. So this provides environmental management framework to deal with environmental issues during planning, design, and construction of roads under the project. And this was published by the Ministry of Road Transport and Highways, Government of India. And we also have the Botswana guidance, which uh, Botswana Guidance Number 5, which talks about planning and environmental impact assessment of road infrastructure, which was published in 2001. And the objective of this guideline is to achieve a comprehensive technical basis for decision making through integrating the environmental impact assessments into the planning process. The So, the transport statement or transport assessment allows decision makers to take into account whether opportunities for sustainable transport modes have been taken up to reduce the need for new major transport infrastructure, whether safe and suitable access to the site can be achieved for all people. Improvements can be undertaken within the transport network that cost effectively limit the significant impacts of the development. So these are certain transport statements or assessment things that decision makers have to take into account before considering new major transport infrastructures, whether all of these conditions are being met or not. And they also need to look up at mixing and clubbing the land use, which is whether to ensure that development projects and the basis for doing individual new planning decisions in most jurisdiction is increasingly aiming to ensure development which generates significant movement uh, in areas where the need for transport will be minimized and the use of sustainable transport modes can be maximized with other planning policies, particularly in rural areas. So they basically need to ensure that major like land uses are clubbed together so that transportation facilities to to particular land users can be linearized or to be sustainably designed. And then sustainable transport modes can be maximized with the planning policies and new developments which are coming up, especially in rural areas because they are underdeveloped at the moment. And then we also looked up at the landscape and visual component in lecture 25. And in terms of legislation, we had, so for the US, we have the National Park Service, which is an organic act of 1916. In UK, we have the National Parks and Access to the Countryside Act of 1949. New Zealand has the National Parks Act of 1980. Europe has the European Landscape Convention or the Florence Convention of 2000. So all of these acts are towards the um, sustainable use and conservation of the parks and infrastructure relating to parks in these specified countries. Then we also have the United States guidance on visual impact assessment and visual resource management. So they were developed in 1970 by the Forest Service and the Department of Transportation and subsequently the Federal Highway Administration. And they set these standards for the integration of aesthetic considerations in large-scale resource management decisions. So this is the older document. This is the newer handbook for scenery management. And we also have the key source of guidance in the UK, which looks up at the guidance, which is the guidance for landscape and visual impact assessment, also known as the GLVIA. And this looks up at a few of the topics around development and assessment of landscape effects, visual effects, cumulative landscape and visual effects, and presenting information around landscape and visual effects. So it considers both landscape and visual components together to achieve consistent, credible, and effective landscape and visual impact assessment practices. And then we also have the guidance on visual simulations, the best practice guide, which was prepared by the New Zealand Institute of Landscape Architects. And we also have the International Finance Corporation's Performance Standard 6, which is on biodiversity conservation and sustainable management of living natural resources. So this also talks about landscape and visual impact assessments. Then we also look up at guidance documents on landscape and visual impact assessments relating to roads and renewable energy in this lecture. So we looked up at the guidance. So in these particular guidance documents, we have the guidance for visual assessment of highway projects, which was prepared by the US Federal Highway Administration in 2015. Then we had the evaluation of methodologies for visual impact assessment prepared by the US National Cooperative Highway Research Program in 2012. Then we have the UK Department of Transport's Design Manual for Roads and Bridges Index 1993, which was later converted to the UK Department for Transport Analysis Guidance, which is the web tag in 2013. Then we had the New South Wales, Australia Roads and Maritime Service 2020 guidance for landscape character and visual impact assessment. And also the Green Highway Plantation, Transportation, Beautification and Maintenance Policy in 2015. You can read more about them in the lecture modules for the course. And then in terms of the guidance documents on landscape and visual impact assessment related to renewable energy, we have majorly towards wind farms and solar PV, solar photovoltaic. And so we had the guidance on environmental impact of wind farms and small scale hydroelectric schemes of 2001. Guidance on the sitting and designing wind farms in the landscape 2017. The guidance on visual representation of wind farms of 2017 again. And then we had the BRE's planning guidance for the development of large-scale ground-mounted solar PV system. PV is photovoltaic. Then we had the Northern Ireland Environment Agency's Guidance Wind Energy Development of 2010 and the Handbook for Scenery Management of 1995. So all of these documents are relating to renewable energy and the landscape and visual impact assessments in renewable energy projects. So this was all of the highlights from this week's content. And then now we're going to look up at some questions from the previous run of the NPTEL course. So we are going to look up at some practice questions, and then we're going to look at week 5 assignment questions. Some of these questions are repeated in the some of these questions are repeated in the okay, yes, in the week 5 assignment as well. So okay. So you can post your answers in the chat box. I will moderate the chat box as well. So the first question is the ICAC-1 guidelines deals with A, cultural, environmental, and social impact assessment, B, language impact assessment, C, economic impact assessment, and D, all of the above. So you can post your answers in the chat box. We talked about this in the module as well, in our highlights section as well. Okay. Okay, so the correct answer is cultural, environmental, and social impact assessment. So these are the AQ1 guidelines are voluntary guidelines for the conduct of cultural, environmental, and social impact assessments relating to regarding developments which are proposed to take place on or which are likely to impact on sacred sites and on lands and water traditionally occupied or used by indigenous and local communities. And this was a part of the Convention on Biological Diversity guidelines. So the correct answer was A, cultural, environmental, and social impact assessment. So moving on to question 2. State true or false. Garibaldi and Turner in 2014 proposed the concept of cultural keystone species. So is the statement A true or B false? Again, we talked about this in our highlights section as well. So, okay, I'm going to please post your answers in the chat box. Okay. Okay. So the correct answer is A, true, which is Garibaldi and Turner proposed the concept of cultural keystone species in 2004, which are basically culturally salient species that shape in a major way the cultural identity of a people, and their importance is reflected in the fundamental roles these species play in diet, materials, medicine, and or spiritual practices. Okay, so Garibaldi and Turner proposed the concept of cultural keystone species. The statement was true. Okay, moving on to question 3, state true or false. Again, human health risk assessment, HHRA, is related with human exposure to chemical contaminants. Is the statement true or false? Again, we looked at this in the highlight section. Okay. So the correct answer is true. The WHO's Human Health Risk Assessment Toolkit is talks about chemical contaminants and its exposure to chemical contaminants. So the statement is true. As you can see, you have the description of human health risk assessment of chemicals and the use of human health risk assessment of chemicals, international risk assessment resources, and all of these things. So the statement is true. Okay, moving on to question 4. Which of the following lending institutions require human health assessment? So we have 1, International Finance Corporation, 2, African Development Bank, 3, Asia Development Bank, and 4, Inter-American Development Bank. So which of the following lending institutions require health effects assessment? So all of these are institutions. Okay. Okay, so the correct answer is D, all of the above. So all of these institutions provide are lending institutions which require the health effects assessment. So they need to provide they provide finance for these things. So the lending institutions are International Finance Corporation, African Development Bank, Asia Development Bank, and Inter-American Development Bank. Moving on to question 5, match the terms given in Group A with their description in Group B. So in Group A, we have the definition of, just going to pause for a while. Okay, so in Group A, we have the definitions, and in Group A, we have the terms, and in Group B, we have the definitions for the terms. So you need to match the terms given in Group A with their description in Group B. And all of these terms are related with land acquisition, resettlement, and rehabilitation. So you can match Group A with Group B. Okay. Okay, so the correct answer is D. That is, eminent domain is the right of a government or its agent to expropriate private property for public use with payment of compensation. So P matches with 4. Then economic displacement is the loss of income streams or means of livelihood resulting from land acquisition or obstructed access to resources, land, water, or forests, resulting from the construction or operation of a project or its associated facilities. So Q matches with 1. So compensation is payment in cash or in kind for an asset or a resource that is acquired or affected by a project at the time that asset needs to be replaced. So R matches with 2. And then S, the host population, which is people living in or around areas to which people physically displaced by a project will be resettled, who in turn may be affected by the resettlement. So S matches with 3. So the correct option was P4, Q1, R2, and S3. So D was the correct option. Moving on to question 6. State true or false. The cutoff date is the date of completion of the census and assets inventory of people of person affected by the project. So is the statement A true or B false?
False.
Yes. So yeah, the statement is correct. So the cutoff date is the date of completion of the census and the assets inventory of persons affected by the project. So this is the date by which the developer has to complete the census, that is the number of people living in the area which are going to be affected by the project, as well as assess the assets of these people who are going to be affected by the projects. But after this date, whatever, so if people who are occupying this area are not who occupy this area after the project after the cutoff date will not be considered for compensation, and their assets will again not be considered in compensation. But the cutoff date is essentially the date by which the people have to is the date by which the compensation has to be determined in terms of the number of people who are living in that area and the assets which they hold. So the statement is true. Okay. So Moving on to question 7. We have again a state true or false. So, as per International Finance Corporation Performance Standard 5, which is on land acquisition and involuntary resettlement, resettlement framework is required to be prepared. Is the statement true or false? We talked about this in the highlight sections as well. So, the resettlement framework has three documents as well. Just a hint. Is this statement true or false? Okay. So the correct answer is true. So as per the International Finance Corporation's Performance Standard 5, the resettlement framework has to be prepared. And it has further three documents, which are the Resettlement Action Plan, RAP, the Livelihood Restoration Framework, and the Livelihood Restoration Plan. So the Resettlement Action Plan talks about the housing facilities, whereas the Livelihood Framework and Plan talks about the job creation, and livelihood facilities for the displaced population. Okay, so moving on to question 8. State true or false? Right to property is a fundamental right in India. Is the statement true or false? We talked about this in the highlight section as well. Talked about fundamental rights and constitutional rights.
True. No, sorry, false.
False. False is correct, yes. So the right to property is not a fundamental right, but it's a constitutional right. Okay, so the correct answer is false. You were right. Moving on to question 9, the right to fair compensation and transparency in land acquisition, rehabilitation, and resettlement Act 2013 makes provision for A, social impact assessment, B, climatic impact assessment, C, biophysical impact assessment, and D, health impact assessment. Can you please mute yourself?
A, social impact assessment.
A, social impact assessment is correct. Yes. So we looked up at the social impact assessment in Land Acquisition and Rehabilitation Act, and we looked up at the steps, the things which the social impact study needs to include, which is the number of affected families, their assets, whether it is physical or economic displacement, whether it is voluntary, involuntary, if the displacement need was the last option and all of the alternatives were reviewed, and the social impacts this will have. Also, they need to hold the public hearing of the social impact assessment at the affected area to get the views of the affected population and to record their statements and sentiments in the final report, which is then published and sent in the local language to the panchayat and municipality of the affected area. So it makes provision for social impact assessment. It was true. Okay, so moving on to question 10, the right to fair compensation and transparency in land acquisition, rehabilitation, and resettlement act makes provision for the following. One, prior consent to payment of compensation through return of unutilized land, and for all of the above. So this is again a so you need to select all of the options which the act makes provisions for. And we also looked up at this in the highlight section under the review. Which of the following provisions does the right to fair compensation and transparency in land acquisition, rehabilitation, and resettlement act of 2013 makes provisions for?
Prior consent. How should I?
Prior consent is correct, but we have other options as well. So in
Payment
the
of
correct
compensation and return of utilization. No, return of utilization range is not there. And yes, all of the above. All of the above.
all of the above is correct.
Yes.
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 So the right to fair compensation, it takes the prior consent of the affected parties. It takes to it looks at the payment of compensation and determination of the compensation. It also returns unutilized act if the payment has not been made within the 12 months since it has been approved. So all of the above is correct. So moving on to question 11, state true or false. In order to address historical injustice, the right to fair compensation and transparency in land acquisition, rehabilitation, and resettlement act 2013 also applies retrospectively to the cases where no land acquisition award has been made. Is the statement true or false?
Yes, yes.
Okay. So the correct answer is true. They need to when no land acquisition has been
What is the actually
made.
the question is I couldn't understand. The question is that
Okay. So the question is that the act, which is the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation, and Resettlement Act, it applies to cases where no land acquisition award has been made. So, so when the land acquisition act happens, you need to determine you need to do a number of steps, which is you need to ascertain whether land acquisition is the last resort option, and all the other alternatives are not applied to this case. And then you need to ascertain the number of families which are affected, their assets which are affected by the cutoff date, and then you need to determine the compensation. You need to hold the you need to do the social impact assessment and publish the social impact assessment report after taking the views of the affected parties. And once the social impact assessment report has been published, you have 12 months for the award of the project. And if this within this 12 months you do not build the project, or you do not start the project and pay the compensation, you this the social impact assessment and the land acquisition thing, it lapses. So you need to do the entire process again. So in cases where this land acquisition award has been made but there has been no development, the act still applies, because they had to do all of these steps for the rehabilitation and acquisition things, but they did not go further with the thing, because after 12 months the rates, also because the rates for the compensation are determined by market value and a lot of other considerations. If you build it after a certain amount of time, the rates get higher, but you are basically paying lesser compensation to the affected parties. So you need to build it in a particular frame of time. So even in those cases, land acquisition still applies. So the statement was true. Okay. I hope that was clear. Okay. So moving on to question 12. Okay. So we have the International Finance Corporation, or IFC, performance standards of particular relevance to social economic impact assessment include. So we have performance standard 1, which is the assessment and management of environmental and social risks and impacts. We have B, which is performance standard 2, which talks about labor and working conditions. And we have C, which is performance standard 7, which talks about indigenous people. So which of these this is again, okay, you have D, which is all of the above. So which of these standards uh, are relevant to social economic impact assessment? Okay, so the correct answer is D, which is all of the above. So the International Finance Corporation has 8 performance standards. out of which performance standard 1, which talks about risk management, talks about social risks and impacts. Talks about social risks and impacts. Performance standard 2 talks about labor and their working conditions. We looked at both of these in the highlight section. Performance standard 7, which talks about indigenous people, also talks about their social economic impact of projects on their livelihoods as well. So all of these standards talk about social economic impact, and thus D, all of the above is the correct answer. So moving on to question 13. Okay, match the terms in group A with their description in group B. So we have group A terms. Group A, we have the terms. In group B, we have the definition or descriptions. So can we looked up at these terms in the highlight section?
3. C.
C, okay,
It's
so
B.
we have. Okay, so the correct answer is B. So these are again terms from the International Association for Impact Assessment, Social Impact Assessment report on the guidance for assessing and managing the social impacts of projects. And so P, which is a social license to operate, is this procedural mechanism which is developed to assist in ensuring the rights of indigenous people to self-determination. Social risk is the possibility for the that the intervention would create, reinforce, or deepen inequality or cause social conflict, and or that attitudes and actions of key stakeholders may subvert the achievement of development objective, or that the development objective or the means to achieve it lack ownership among key stakeholders. So all of these are social risks, which are basically uh, risks which lead to social disintegration of communities. And then Q is which is the free, prior, and informed consent, FPIC, matches with 3, which is the level of acceptance or approval of activities of an organization by its stakeholders, especially in local impacted communities. So all of these terms are defined in the social impact assessment guidance. So just a tip for all of the learners is to remember the key terms in the definition. So because the definitions and these terms are important, so you should just make a note of the key definitions and their description from all of the lecture units. Just a tip. So the correct answer was B. So moving on to question 14. Which is a true and false. So non-technical risks relate to managerial, legal, social, and political issues faced by a project. Is this true or false? This is again a definition based question from the same report on social impact assessment. Okay, so the correct answer is true, which is non-technical risks are related to managerial, legal, social, and political issues which are faced by a project. Okay, moving on to question 15. Match the EIA typologies as given by the World Bank Guide 1997 for the road projects of Group A with their description with their description in Group B. So we have EIA typologies for road projects, and we have their description in Group B. Okay. So the correct answer is A. So project-specific EIA looks up at assessing individual new roads or new public infrastructure projects. They look up only a specific project, whereas programmatic EIA looks up at a number of individual projects and delivers them together as a package. So P matches with 2 and Q matches with 1. Whereas sectoral EIA is strategically assesses all project types, all projects for certain types relating to transport. They could be transport infrastructure and other things in the relatively larger geographical areas, whereas regional AIA examines planned projects in a specific geographical area at the subnational level. So the correct answer was A, that is P matches with 2, Q matches with 1, R matches with 4, and S matches with 3. Okay. So moving on to question 13, state true or false. Indian government provides environmental impact assessment guidance manual for highways. Is the statement true or false? Again, we looked up at this in the highlight section. Okay, the statement is true, which is correct. So we have two documents for highway projects, which is the guidelines for environmental impact assessment of highway projects in 1989, and we had the environmental impact assessment guidance manual for highways 2010. Okay, so the statement was true. So moving on to question 17. In UK's web tag guidance, the full form of tag is. So we have A, Transport Advisory Group, B, Transport Analysis Guidance, C, Technical Analysis Guidance, and D, Technology Advisory Group. Okay. So we discussed this in the transport section in lecture 25. And we were in the lecture, we were talking about guidances, policies, and legislation. So, okay. So the correct answer is B, which is transport analysis guidance. So the UK Department of Transport has this transport analysis guidance or web tag. So tag is basically transport analysis guidance. So B was the correct answer. Okay. So again, abbreviation of terms is important from the point of view of examination. So you can look up at the abbreviations and their full forms. Okay, so moving on to week 5 assignment. So we have covered a few of these questions in the previous section as well. So we're just going to look up at questions so as not to repeat them. Okay, so question 1, which among these has not entrenched HIA or health impact assessment as part of the ESIA process? So we have A, Thailand, B, Korea, C, India, and D, Ghana. So we are discussing this because the deadline for for submitting the assignment has passed. So we can discuss these questions now. Okay. So the correct answer is C, India. So India has still not entrenched health impact assessment as part of the social impact assessment process. Okay, so moving on to question 2, which is match the terms given in Group A with their transition project outcome in Group B. So Group A has the negative impacts of rehabilitation or resettlement acquisition projects, and Group B has the transition project outcomes. So you need to match Group A with Group B. Okay. So the correct answer is B, which is B match. So increased morbidity is associated with improved health care. So the developers have to ensure that improved healthcare facilities are provided for the displaced people. Then loss of access translates to restoration in community assets and services. So loss of access to natural areas or forest areas translates to restoration of community assets and services to the affected people because of loss of livelihood. So they need to be given these assets and services in order to ensure that their livelihood sustains. And then social disarticulation translates to networks and community rebuilding at the host population site. so that these people do not feel socially disintegrated from their new location and people. So P matches with 2, Q matches with 3, and S matches with 1. Okay, moving on to question 3. According to the Cultural Keystone Species by Garibaldi and Turner in 2004, culturally salient species that shape in a major way the cultural identity of a people. Their importance is reflected in the fundamental roles these species play in diet, materials, medicine, and/or spiritual practices. Is the statement A true or B false? Okay, so the statement is true, which is correct. Okay, so moving on to question 4, which among the given below defines eminent domain? So the the options are basically the eminent domain's definition. So the eminent domain is the right of the government or its agent to expropriate private property, but for what use and with or without payment of or compensation. Okay. Yes, this is the correct answer. The eminent domain is the right of the government or its agent to expropriate private property for public use with the payment of compensation, of course. So the government can take private property from individuals for public use projects, and they have to pay certain form of compensation in terms of monetary or financial value of the property. So an example of this is the road widening projects. So when the government decides to widen the road width of existing roads, they can take up the extra width from the private property and pay some form of compensation for widening roads. Okay. Moving on to question 5, we have match the terms given in Group A with their description in Group B. So I think we looked at this in the previous section as well.
It's D.
Okay, we have an option D, which is correct. Yes, so the settlement is the process of relocating people and communities from one place to another. Economic displacement is when they lose their means of livelihood because of land acquisition or obstruction of access to their resources on which their livelihoods depend. And then compensation is payment in cash or kind in for the assets or the resources which are required or affected by a